Now, often you guys, when we do these trainings, I do say, if you have questions, comments, feedback, anything else you'd like to see training on, please let me know. And so I'm going to share my screen with you and share with you where this one's coming from. So on my YouTube channel, if you're not a subscriber yet, go to Elite Agent Training on YouTube and subscribe there. But I got this comment right here, and this is going to be the source of our training today. It says, you may want to do a video about what happens if the seller chooses to accept an offer from an unrepresented buyer and decides to go forward and sell their home to someone without an agent, using a public version of the contract, a contract the buyer wrote themselves, or a version from the internet that is not created or backed by the Realtor Association. I suspect that the buyer will be responsible for their own errors or omissions in this case if things fail. I also suspect that if there are omissions or clauses not in the buyer-created contract that are normally in the Realtor Association contract, those don't apply if accepted, and the court will go by the language of the contract used in the transaction, even if not lawyer-created, unless the issue is mandated by law. Some of my predictions that we are going to see as time goes on post-settlement: simpler contract language. Not everyone will use the Realtor Association forms. Seller's agent should note any differences in form language used. Sellers paying for less to get a property sold. No buyer agent commission if the unrepresented buyers don't think to ask the seller to pay for repairs. Make concessions for defects, termite damage, etc. They will not be included on the contracts. More competitive agent pricing models, and it's not every realtor that's going to charge the same rate. Some might charge a commission, some a flat fee, and others an hourly rate for their services. Buyers may also have to pay their own agents if they want representation, if the seller won't pay the fees. More as-is sales, again, the result of a simpler contract language on the public version of forms, and things that unrepresented buyers don't think to ask about when they write their own forms or contracts without agents or attorneys. And then he says some transactions will fail because some unrepresented buyers don't know what they're doing. However, this doesn't mean that all transactions that involve an unrepresented buyer will fail. Someone who does enough research or has experience buying a home before could easily succeed representing themselves in terms of completing a real estate purchase on their own. If one is an all-cash unrepresented buyer and they have decided that this is the property they want, things could go very smoothly, for example. It will be more complicated and risky when financing is involved or sale of other properties are involved or are for unrepresented buyers. And then he says errors and omissions rates go up due to increased errors, omissions, and litigations from unrepresented buyers. So I want to break this down a little bit. And I think he makes some valid points in here, but I want to talk about a couple of things that he mentions with some questions on. He says, I think this would happen. So let me make some definitive comments on some of these items here. Okay, first of all, what happens if the seller chooses to accept an offer from an unrepresented buyer and decides to go forward and sell their home to someone without an agent, using a public version of the contract or a contract the buyer wrote themselves, or a version from the internet that's not created or backed by the Realtor Association? So if I stop sharing the screen here and we just have this conversation, let's assume that I am the listing agent. Buyer comes along, unrepresented, and he's using, let's do the three different scenarios. He's using a version that he made himself. Now, this isn't completely out of the park, an unrealistic concept, because I've seen very intelligent people. In one case, he was an international business owner, very successful, very wealthy, and he wanted to, I was approaching him as a for sale by owner, and he was putting me off, saying, I kind of want to do things on my own. And he calls me up one day and he says, hey, I'm wondering if you can help me out. I got an offer on my home and now we're getting sued. I said, okay, tell me about the offer. And he shares it with me. And on a blank 8.5 by 11 sheet, the other guy, who was also very successful, had handwritten, we make an offer, we hereby offer to buy your home for this price. And they both signed it. Okay. These are successful, intelligent, business owning people, and they did this, right? So yeah, these things could happen. Let's say that you're, again, we're assuming here for the sake of this, by the way, if you are, for the sake of this video, if somebody from the public is watching that and they're a for sale by owner, they don't have representation, then all of these things could happen to them and they may not know any better. But for the sake of this, we're training real estate agents. So let's say that you're the listing agent, that offer comes in. What are your options? You've got a handwritten offer by somebody. It's obviously going to be problematic. Can you say, I'm sorry, we don't accept offers handwritten like this? Or can we say we can't accept offers handwritten? Could we accept it if we wanted to? Donald, you got to.
Yeah. So I had a contract come in yesterday from a sibling of the buyer, and the guy who does land acquisition for a large land acquisition group locally, and they wrote me this offer, and I just sat down and said, hey, there's, before we get into this, before I present it to my seller, I've informed my sellers that this is here, that what you've tried to present here. I said, but let's spend some time on a call and write this on the proper forms. I said, there's a few things that that need clarifying, a few more points that are on the proper state form that help us protect you and the seller. And it went well. I spent probably an hour and a half, 2 hours with them rewriting their contract yesterday. And then I sent it out, they dot looped the new contract, and then I took it to my sellers. So I mean, it happens. But the other thing that I've always explained, I've had countless too, where it's the old farmers that say, oh, well, I'm used to doing a deal on the bed of my truck, handshake deal on the bed of the truck. And I've said, that's great. I said, I'm also a man of my word. But if we're both men of our word, you don't mind if I put that handshake in writing. And I've never had anyone that's retaliated at that point. I'll say, yeah, we can make the deal here, but I'm going to point out a few things to you that you may not have thought of.
Okay, so I want to comment on a couple of things that you said. First of all, good old boy farmer comes and says, I want to do a spit and a handshake. First of all, since COVID, nobody's spitting anymore. We're not doing that. That's out right off the, okay. But second of all, a handshake, we have something in Utah called the statute of frauds. We don't do verbal agreements. They are not enforceable. And so we just educate them and say, sorry, everything when it comes to real estate law, we have to have it in writing. All right. Now, second of all, Donald, you mentioned that you got an offer from somebody, so you helped them rewrite it. Now, the risk associated with that is agency by implication. Does this person understand, hey, I'm not representing you. I'm going to help you with that, with these forms. I'm going to help you write it up. And so you help them write it up and you present it, and the deal progresses forward. And later on, they found out that they could have had inspections that they didn't get done. And they decide to sue, and they call an attorney, and they're telling their story to the attorney, and the attorney says, well, who helped you with this contract? And they say, well, my agent helped me. And so the attorney's like, your agent should have told you that you could do these inspections. Well, I didn't know that. And now the attorney names you in a lawsuit. And this is agency by implication. And I always say this is a sword that only cuts one way. It only cuts the agent. So it never hurts the member of the public that doesn't know any better, right? It can only hurt the agent. And so we have to disclose. And Donald, I'll go over some forms you may not be aware of that we've created that we use to talk about this and have this discussion with people.
And I hit them with, one of the first thing they understood is an email disclaimer, plus the contract we wrote had the unrepresented buyer's disclosure in there. I am an advocate of a buyer always having an inspection for that same reason. The moment we remove it, whether it's their idea or not, is the moment you open the door for your seller's liability and yours as an agent. So I'm go ahead. But yeah, go ahead.
Okay, but I don't know that you're aware of the new form that we've created. So we'll be covering that because it will help protect agents in this exact scenario. So first of all, my question is, what do we do with this offer? We've gotten an offer on an 8.5 by 11. Do we outright reject it? What is our obligation under the law?
You have to present any offer given to your seller.
We have to present any offer that we have. So we take it to our seller and we say, hey, seller, we got this offer. And quite frankly, we don't want to seriously consider this because here's all the problems this could create for us. Now, with your permission, I can go back to this buyer and I can make a couple of offers. I could offer to represent them in a limited agency scenario, which is legal in Utah, right? In which case I help them fill out the paperwork correctly. As such, I'm going to have liability for them and for you. And I explain the concept of limited agency. If they say, yeah, I think we would like that because this seems a little bit risky, just doing this all on our own, or having them do it on their own and whatever, we think that might be the best case scenario. Then, of course, we'd have buyer and seller sign a limited agency consent agreement form, and we can proceed in that way. Otherwise, if they say, yeah, go back to them and tell them to create the right, to write it up on the correct contract. But the first thing I want you to understand is they can write it up on anything that they want. We have to present it to our clients, but we're also going to present it to our clients in a way where we counsel them. Here's the dangers of working with this contract that is poorly written. I want to share with you a contract that I did in preparation for this. Okay. I went online and I just typed, I need a purchase contract to buy a home. And I got some sponsored parties. I picked the top sponsored party. If I scrolled down about a page, I could see the Division of Real Estate's form. Okay. But I'm a member of the public that doesn't know any better. And so I picked the sponsored party. Now, in order to come up with this form that I'm about to show you, it had me answer like 20 different questions. And again, I'm going through this as if I don't know what I'm doing, right? I'm a buyer trying to make an offer on a property, but I don't know the ins and outs. And as I got into these questions, and there were probably at least 20 questions, I thought most people don't know any of these things. And then me, naturally, I was just role playing as myself. I'm like, okay, this is overwhelming. I just want to see the form to see if I can use it. And I started skipping through the questions because there were so many. I didn't know what they meant. And I was just trying to do my best. And in the end, I got this real estate purchase agreement. And I did answer the question that it was for Utah. Okay. So this should be Utah specific. And I've done this exercise in the past and gotten contracts from other states. But let's go through this really quickly. Now, again, if we get presented with this offer, it's obviously much better than some handwritten offer, I want to buy your property, and everybody signs it, right? This is so much better than that. So we present it to our clients. Do we advise our clients to work with this, or can we, again, go back to the buyers and say, I'm sorry, there's problems with this contract that you found, and I can either help you with it or I can direct you to where you find the proper contract and you can redo it all, right? So let's go through this one in a little bit of detail. Now, there's a lot of problems I can find with it, but I went through and I found just a few. So first of all, we go down to section 1.
Can I ask one question?
Yeah.
So back in the day, and even supplying, and again, we'd have to direct them through it with a disclaimer that I am not your agent because the problem was back in the day, people would provide a contract and that created the implied agency.
So I'll share again, Donald, that question is addressed exactly on the form that we have created for this.
Awesome.
And I'll get to that later on in this training today. But yeah, that's a great question. So we have it on there. So first of all, when we're looking at this one, we go to section 1, and the property situated here and here. It includes fixtures and improvements located on the property. Now, do buyers and sellers, well, our sellers are going to have us, but do buyers understand what fixtures are? No, that's a concept we learned in real estate school, right? They didn't learn it anywhere. And so what exactly is included in this contract? Now, this is a well-written contract. And if you didn't see, it's from the Law Depot. And I don't know who these guys are, and I'm not disparaging them in any way, because honestly, all of their clarifying questions that as an educated real estate professional, I could have answered, but as a member of the public, I probably wouldn't have known the answers to. So I just skipped through all of them. And anyways, this is the form that I ended up with. So could there be lawsuits from you guys who have done this for years, in some case decades, Could there be some problems which ended up in lawsuits for my seller because we haven't specified exactly what's included and excluded in the sale of the property? We just got this nebulous, it includes fixtures and improvements. We could end up with a lawsuit right there, right? Using a legal form, it can create problems for us because it's not the best version that we could use. Okay, we jump down to 7. We've got title policy. They're going to issue a titles policy. If we go over and give me a second to sign in and we can compare this with our purchase contract. When we talk about title insurance down here, it specifies what kind of policy we're getting, right? With this one, it doesn't specify what kind of policy. There are a couple of different policies that could be offered. That could create some confusion later on. If we jump down to section 9, prior to the closing date, the seller will deliver the seller's existing property survey to the buyer and to the title company, along with the seller's affidavit in relation to the title company's approval of the survey. This survey must have been completed within the past year. Folks, if your seller signed this, they're all going to have to go out and get a survey done, right? That can drag things out. That could cause you to miss some deadlines, and it's definitely an added expense. And this isn't something that's in the standard contract. So again, the point that I'm making here is we can present this offer to our sellers, but our job is to read through it and understand the correct forms enough that we can have a discussion with our seller and say, this is why, we've got this offer, but this is why we don't want to entertain this offer as it's written. Okay, so I'm going to keep going down. We can jump down to disclosures. Seller doesn't know of any material facts that would affect the value of the property except those observable by the buyer or any known to the seller, which are disclosed in this agreement and the attached addenda. So that's a little bit different than our section. If we jump over here to seller's disclosures, we've got the written seller disclosure for the property. And again, the Board of Realtors has created a 15, 16-page document for this purpose. Lead-based paint disclosure is mentioned later on in this contract. Commitment for title insurance, copy of CC&Rs, copy of recent minutes, copy of any tenant leases. All of these other things are required by the seller's disclosures, as opposed to what we see here. We're just disclosing anything that we know, right? There could be some things missing, and anything that's missing in this could lead to a lawsuit. We jump down even further, and we've got this one. This is an interesting one. Neither the seller nor the buyer is obligated to pay for any lender-required repairs or remediations unless both parties agree in writing. That's fine. If repairs will exceed 5%, the lender has the sole option to terminate the agreement. Boy, that's a fun one, right? Alan, you want to be terminating agreements?
No, I do not.
And they're making a lender a party to the contract. You can't.
Yeah, which the lender's not agreeing to. So that's a little bit wild right there. We jump down to due diligence resolution. The seller is going to complete all the agreed work, repairs, treatments, and improvements prior to the closing date. All right. The work to be completed must be done by individuals who are licensed to perform such tasks, and all required permits and regulations must be obtained. Again, we have specific forms because this type of language has caused people to go into lots of lawsuits. So we have a particular addendum that was created for us by the Association of Realtors called the Resolution of Due Diligence Addendum that we use to address these issues. Then we drop down here. This is one that's very interesting to me. If we go down to section 35 and we talk about default, if the seller is in default, the buyer can seek specific for performance. We have that in the state approved form. They can seek other relief as provided by law. That's in the state approved form, a combination of any remedies above, or they can treat this as terminated and get the earnest money within 10 days of cancellation. Now that's different, right? This one actually harms the buyer. The buyer's just getting the earnest money back, but they're not getting an equivalent amount in liquidated damages, where if we go down here to the default section, if the seller defaults, the buyer accepts as liquidated damages. Let's see. Seller defaults, the buyers can cancel the purchase contract and get as liquidated damages sum equal to the earnest money deposit. So basically, we return the earnest money and get that much back in damages, right? It's not just a return of the money. So again, the point with this little exercise is I want you to understand what you can and can't do. Some agents are thinking, hey, we're the listing agent. We have to use whatever form they bring to us. So I want to share my screen with you now and take you to the law. What does the law say we have to do? All right, this is the section of, let's see here. Okay, this is, we're looking at 17A. These are affirmative duties required of all licensed individuals. I'm looking at admin rules. So this is the law, okay? We're looking at the law here. We're going to jump down here to 17A, and it's going to refer us to somewhere else. It says, in negotiating and closing a transaction, a licensee may fill out those legal forms as provided for in section 61 2F 306. So we're going to jump there. So this says, a real estate licensee may fill out only those legal forms approved by the commission and the attorney general and those forms provided by statute. Now, a principal broker can fill out any documents associated with the closing of a real estate transaction. A branch broker can fill out documents associated with the closing of a real estate transaction if designated by the principal broker. A real estate licensee may fill out real estate forms prepared by legal counsel of the buyer, seller, lessor, or lessee. So could we use these forms that they're creating? I mean, maybe they used this website up here and they're called Law Depot, and that's their legal counsel. Could we use that if we wanted to? Sure, we could. But that's not going to be the best thing for us, because we're going to communicate with our sellers and say, here's all the problems using this form would create. Now, if the commission and attorney general have not approved a specific form for the transaction, a principal broker, associate broker, or sales agent may fill out real estate forms prepared by any legal counsel, including legal counsel retained by the brokerage to develop these forms. And from here, I'm going to take you to the form that we have created. All right. So this tells us exactly what we can fill out. We can fill out legal forms approved by the commission. Now, Donald had a question of where could we, how can we provide forms to the client? Well, all we do is we say, hey, there are state approved forms for this. If you go to realestate.utah.gov and go to forms down there, here's some state approved forms, real estate purchase contract. I could even send them that link. Now, I'm not providing them with the contract. The state is providing them with this contract. I can provide them, and we've got here very limited forms that are approved by the state. So if you want to look at this list right here, and at least half of this list is seldom, if ever, used. So look at that list really quickly, and then we're going to jump over to the MLS, and I'm going to back out of this standard form, okay? And I'm just going to show you the library that we have. All right, there's some forms over here that we can use. Some of them are required by law, but look at this library of forms that we have created for us. Now, if you'll notice, some of these have stars by them. In fact, most of them do. If we get down to the bottom, you'll see that this is a copyrighted form from the Utah Association of Realtors. So you wonder what your dues go towards? This is one of those things. We have attorneys that create forms that protect us. Now, some of these say this form is the original work and authorship of the Utah chapter of CCIM or is provided by the Utah Division of Real Estate. So some of these are commercial forms. Some of them are provided courtesy of the Utah Division of Real Estate, and they're just provided here for our convenience. Now, the ones that are available to the public are the 3-star forms. All of the 1- and 2-star forms, no, they're not. So you scroll through this list. This is one of the value propositions that an agent brings to the table. All of these forms solve a different problem, okay? And without access to these forms, you're opening yourself up to some liability. So we've taught for a long time that having an understanding of these forms is very important to us. Now I want to jump over to one that we have created. So again, we go back to, let me close that out. We go back to the law, and it says that legal counsel could be retained by the brokers to develop forms that we might see a purpose for. So we have developed this form right here. It's called the Equity Unrepresented Buyer Disclosure. So we pull this up, and in fact, the video that generated this discussion that we're talking about today was a video going over this training. So I would, or introducing this form to you. So I would encourage you, if you haven't, go to my website and watch the training on this form. But as we go through this unrepresented buyer disclosure form, you'll notice that if I want to, by the way, that's a really handy search bar for you. If you're not quite sure of the entire name of the form, but you know part of it, or you don't know where to find it in those hundreds of forms, you can start typing in the name in that search bar. I was just telling that to an agent, I think it was this morning. Okay, so let's look at the difference between these two forms. This is the form that is copyrighted by the Utah Association of Realtors, which in light of this settlement agreement, I thought this is not sufficient for us. So I asked our attorney, in accordance with the law there, to prepare a better form. What this simply says is, hey, here's what a seller's agent does. And it says we've got fiduciary duty, which involves loyalty, full disclosure. So it's basically a definition of fiduciary duty, which means absolutely nothing to the layperson. They don't understand what these terms mean. Buyer's agent, hey, you've got fiduciary duty to a buyer. Could be a limited agent. You got a fiduciary duty to both, but you're limited in certain aspects of that. And then in bold, it says that we're only representing the seller, and the buyer acknowledges that they've been entitled to have their own agent, but they're choosing not to. But it doesn't define what that means. And so I've had our attorney create this form. And this says that the company cannot and will not. Now, this is not only an education to the client, to the buyer. It can be used as education to the seller. And I'll show you how to do that here in a bit. But it's also education to each of you as an agent. Donald made the comment very early on. Hey, we help somebody out. What can we do? What can't we do? This is the form from the attorney's perspective. And what I did is I sent to the attorney, hey, here's a lot of the stuff that a buyer would do for their client. When somebody says, I don't want representation, they should know what that means. Because this other form approved by the UAR or provided to us by the UAR doesn't define what that is. It simply says, hey, we've chosen to go without representation. So this form says, hey, we're not going to give you an opinion of the value of the market. We're not going to assist you in drafting offers or counteroffers. The company may provide buyer with a blank state-approved real estate purchase contract and blank addendum. Because again, if we go to the state website, those two forms are available to the public. We're not providing them with any legal forms. We're simply directing them to where they can get those forms, right? But we cannot assist them in filling out those forms. So, hey, here's where the forms are. This is available to everybody in the public. But the minute I get involved and assist you in filling them out, I create agency by implication, which I cannot do, right? Can't help you in meeting your deadlines. So that does include their due diligence deadline. In fact, I can't recommend inspectors, lenders, appraisers, or title companies. All of those things create agency by implication, which causes problems for us. So again, I'm not going to go through this training in a lot of detail. Donald, go ahead.
I'll try to behave myself, but isn't it in your client's best interest as a listing agent to make sure certain things happen so that that deal can be completed?
Yes, it is. It is. But it's also, so this is where we have this discussion, right? And this is where I would use this form. So let's say that I get an offer on one of our first two examples. If I go to this comment that was made, right? I get an offer and it's a contract the buyers wrote themselves or a version created on the internet, which we've looked at in detail and we've discussed the problems, right? Again, my job, my duty is by the law, I have to take this contract and present it to my client. So I take it and present it to my client. And along with this contract, I say, you know what? Let me show you this form as well. So I'm going to bring this form along to enable this discussion. And I'm going to say, we've got this offer and here's some problems that this offer would create for you if we were to accept it. If we were to entertain this offer as it's written, here's all the extra liability this could cause for you. Now we have two options. I can reply to this unrepresented buyer and say, hey, I'm sorry, we can't consider your offer as it's written. It creates significant liability to the seller. And so we're not even going to entertain it as it's written. However, you could go to this website and direct them to utah.realestate.gov. Here's where you would find the state approved form, and you could write up your offer on a state approved form. Now, again, is it going to solve all of their issues? No, there's a lot of things in there that the state approved form, we saw hundreds of forms that address issues that we're going to be facing here. But we can direct them to that basic form. And so we have this discussion with our seller. Hold on a second, Donald. We have this discussion with our seller. We say, I can route them to this generic form, but even if I route them to the correct form and they're using the proper form, here's the rest of the stuff that I cannot do with them. I can't help them fill it out. They'll still probably make mistakes with it. I can't help them in meeting their deadlines. They could miss their deadlines and that's on them. I can't refer inspectors, lenders, appraisers, or title companies for the buyer to use. Now, Donald says, well, isn't that in your client's best interest? Yes, it absolutely is in your client's best interest for them to do this, but you can't. Okay. Donald, are we very clear on this? We cannot do it.
Yes.
So it's in my seller's best interest that they have a good lender. It's in my seller's best interest that they have a good inspector. But I cannot give that to them without creating agency by implication. And so this is where I have this discussion with my seller and say, it is best for them to have these things. And it's best for you too. Because if they don't do these things and they figure out later on that they feel later on that they were possibly burned by this, they can come back and they can try to make a fuss and they can try to sue you, and all of these different things could happen if they don't have good people in their corner. So one of the options that I have, Mr. and Mrs. Seller, is I can go back to them with this form. Now, remember, I'm representing the seller here. I'm representing the seller's best interest. So I can go back to the buyer and say, hey, buyer, you've got two options, both with the blessing of the seller. I can either route you to the state approved forms and you can rewrite things and do things on your own, or I can help you out. Now, if you do things on your own, I will also have you fill out this form. And this means, and then we walk through this form and say, this is the things that I cannot help you with. However, the seller has authorized me to offer a limited agency scenario where they will compensate me because it's in their best interest to make sure that this is done correctly on your behalf. Okay. Now, again, this is all part of our conversation with the seller. And we say, here are your two options. I can help them, and it is in your best interest, seller, if I do help them. And I'll tell you what, it helps if you've made this conversation right up front in your listing presentation. So if you've had this conversation up front in your listing presentation and you could incorporate this form when you're explaining your commission, then later on you get an offer that isn't correctly drafted, then you can bring this back and say, remember this discussion we had when we listed your home? Well, here we are in this exact scenario. Okay. So it's going to be tough for us to get this buyer across the finish line if somebody's not helping them. I'm happy to help them. And here's how I can do that for you. So then we go back to the buyer and say, I'm happy to help you with this stuff. Or you can choose to remain unrepresented, in which case I'll have you sign this disclosure, and then I won't do any of this stuff for you. No matter how much I want to, no matter how much it benefits my seller, I can't do these things for you. And, without creating risk for myself. So I won't, right? And you won't do it because this is the direction of the principal broker. And he says, we can't do these things because we could get sued, right? Nobody wants to get sued. So
Eric,
now we've had, yes, Richard.
how would, and I know how I've done this in the past, but certainly with the lawsuit and everything going on, we're rethinking and retooling some of this stuff. How would you describe to your buyer and or seller in this type of a scenario, what does it mean to be limited?
So now we could go directly to state law because it does define it there, and it says we're limited in our full disclosure, because obviously now I can't disclose everything that I know to you without compromising the other concept of fiduciary duty, which is the confidentiality, right? So if I disclose everything to the seller that I know, then I'm compromising my fiduciary duty of confidentiality to or from the buyer, right? So in a nutshell, what I would say is, hey, with limited agency, I'm looking out for both of you, but I can't disclose things that I know about the seller to the buyer and vice versa, things that I know about the buyer to the seller that would compromise their negotiating position. And that's to me, that's the easiest summary.
In the past, I would have used language like, I can't do anything that harms your ability to negotiate or the other party's ability to negotiate. Is that still a fair assessment?
I think that's great. Yep. Yep, I think that's very fair. Okay, so now we're coming around to this concept of how could we have either avoided all of this, or how could we have set ourselves up so that when these scenarios come about, we're better equipped to handle them. And again, this is all from the perspective of a listing agent. So I'm going to share another screen with you now. And on Monday, yesterday, with our marketing class, we talk about, this marketing concept of always be closing, right? Now, I'm not a fan of necessarily, close all throughout a presentation. I am a fan of closing though. Like our goal in approaching somebody, our goal every time that we sit down and we do a presentation with somebody isn't simply to provide free information. Our goal is to walk away with a signed agreement. So when we sit down with the seller, one of my favorite closing techniques is to provide a couple of options for them. So rather than go through my listing presentation and say, do you like me? Or I could use a hard sell technique. So, all right, I've got the paperwork right here. If you'll sign here and here and here, we're ready to go. I don't like any of those. I don't like the awkward guy asking a girl out on a first date where I picture a cartoon character kind of, head down and feet scuffing the floor saying, so will you go out with me? Because that's how honestly I felt when I was doing my first listing presentation, right? And then you hear a lot of these trainers and they're the hard sell and close. I don't like that either. I like to get to the end of my presentation and say, okay, I've got a couple of different options for you. Which one do you think you guys would like to go with? Now, we've got the first one, which is what I recommend, okay? And this is where the buyer has an agent, where most of our buyers coming in will have an agent. And although we can't offer compensation through the MLS, we can offer it through other mediums. I can post it on the videos that I do. I could post it on my own website. I could post it on social. media, I can say, hey, we're offering a commission to a buyer's agent. Now, most agents are going to have a buyer's agent, so that's a good thing, right? If we don't offer it to a buyer's agent, then they could come in either unrepresented or with an agent. And if they come in with an agent later on, they're gonna try to negotiate this compensation anyways. So here's how this works. If we took, our total commission would be 6%, 3% to me, 3% to a buyer's agent. And by the way, you guys can negotiate anything that you want. Okay, these are just sample numbers. You could do 2.5%. You could do 2% to you, 3% to a buyer's agent. It's all completely negotiable. But this is how it would break down, right? List price was 500,000, 3% is this and this. This is your net proceeds before any other costs. Now, another option is if we are presented with this scenario where somebody comes to us and they don't have an agent, or I, in all of my marketing, find somebody and I bring them to your home. Now, if I took them to any other home out there, I could make 3% as their buyer's agent, but I'm going to bring them to your home and try to sell your home. That ends up being good for both of you, right? This buyer has kind of an in, they know the guy selling the home, right? And as a seller, you're going to save a little bit of money. So if I'm representing the other party, then I'll do that for 5%. And here's how that works out. And, there would be your net $5,000 difference there. Now, if the buyer has no agent, then you could save a little bit on that buyer agent commission. However, it's essential to note that these can be more complex, more time consuming because there's nobody helping that buyer out. And again, we've got that other form that we've created where we use that to properly disclose and identify these issues right here that can be created. So if the buyer has no agent, I'm still going to charge you 4.5% because it's not going to be easy. There's going to be extra liability. And I'm going to, at this point, I want to jump back to this comment that was made. I think it was his very last thing. Errors and omissions rate go up due to increased errors, omissions, and litigation from unrepresented buyers. Folks, I think this is an absolute eventuality. If unrepresented buyers continue unrepresented and they don't understand, like if we're helping them out partially, but not all the way, hey, I didn't understand that you could be helping me out or that you weren't representing me. I thought that you had an obligation, a duty to the public to make sure that all of these things were done. These were all lawsuits from 25 years ago. Okay, this stuff was commonplace before we had this transparency that the MLS created for us. I really don't think this settlement agreement is good for the public. And as a quick little side note, which I'm curious to watch play out, there are MLSs suing right now the DOJ saying, hey, you can't limit our free speech. When you tell a seller that they can't post through their independent party, that they can't advertise what they're offering, you're limiting that seller's free speech. That's a violation of their amendment rights. So that's a lawsuit going through right now, and I wholeheartedly agree with that. So we'll see where that plays out, right? But for now, this comment that he made that errors and omissions go up, it's true. There is greater risk for you dealing with an unrepresented person. And so when I go back and share my options here, if they say, hey, if the buyer has no agent, why aren't you just doing it for 3%? And again, that's where I come and say, because there is significant liability. So here's a summary of your options. Here's the difference in savings that you're going to experience. And here's your consideration. Offering compensation to a buyer's agent through other mediums can still make your home more attractive to buyer's agents, potentially leading to a quicker sell. Complexity of transaction. Transaction without a buyer agent can be more complex and may require more time and effort from the seller and the listing agent, and the extra legal risk. Having an uninformed buyer increases the legal risk for both the seller and the listing agent. An uninformed buyer may not fully understand the legalities and obligations involved in the home buying process, which can lead to misunderstandings, disputes, and potential lawsuits. This added risk necessitates a higher commission to compensate for the increased effort and risk management required. And I also would say to the seller, I would say, we do not reward people for putting us at risk. They're putting you at risk, they're putting me at risk. And so I'm not going to do it for just 3% because that's basically offering a reward to this buyer because they're going to negotiate that down in price, right? That extra money doesn't go to the seller typically. The buyer's coming in saying, hey, I don't have an agent, so this $500,000 listing, I'm effectively offering full price by offering $485 because I don't have an agent. I'm doing this all on my own. There's a reason they're doing it on their own, and they think they're saving money. And our response to them, because we've had the discussion with our seller and our seller has told us to give this response, our seller says, you go back to them and you tell them, because you have no agent, you represent a significant risk to us, the seller, and to us, the brokerage. And we don't consider you $15,000 less being a full price offer. Okay. We'll go ahead and entertain your offer, but we're not giving you $15,000 off for it. That is not full price for us because your risk is greater than the risk of every other offer that we could get. So anyways, that's our closing right there. When we say, okay, sellers, here's your 3 different options. Which one do you think you would like to have? And let me go back and share that screen with you again.
Where can we find that? These pages?
I just wrote this up this morning.
I
I'm
know,
happy
I
to
like
share
it.
it with you.
I'd
I'm
love
happy to share it
love
with
you
you.
to share it. Thank you.
But we say, hey, seller, here's your options. And the price difference between all 3 of these, and by the way, 500,000 is the average price of a home in Utah right now. So the price difference of all 3 of these is $7,500. That's pretty small when we're talking about some of the liabilities and stuff that we're facing, right? And again, if I signed this option 1 where we offered 6%, but somebody comes along and I end up doing it for both sides, I'll still give them the 5% option. And I could add that as an addendum to my exclusive right to sell listing agreement. And I've got an agent that does that every time now. But this could be a good discussion for closing. So again, when I get to closing, this makes an easy closing argument for me. I'm not saying, so do you like me? I'm saying, which one of these fits your scenario the best? Which one of these do you think will best serve you? And they talk to each other, you know, husband and wife, whoever the homeowners are, and they say, you know what, kind of like number 1, we think that makes the most sense. And if number 2 comes about, then we would do that. But number 3, we don't love that idea of somebody not having representation. Okay. So they have the discussion. They say, we kind of like number 1, we kind of like number 2. And I say, great, here's the paperwork. Let's put this in writing. In fact, if you choose number 1, we'll add an addendum that involves number 2 as well, so that you get the best of both worlds.
I've actually done it that way for most of my career.
Yeah.
Where
I
if
have
it's
too.
a dual agent, I give them a break.
Yeah. I have as well. And my favorite closing is one where it's not about me. It lets them, I say, okay, here's your options. Which one do you like? Which one fits your needs the best? And they have that discussion amongst themselves. And they say, okay, we like number 1, we like number 2. I say, great, here's the paperwork for it. And I come prepared with my exclusive right to sell agreement. I come prepared with an addendum to that exclusive right to sell agreement. And I also come prepared with an exclusive buyer broker agreement, because one of my options is I give them a greater discount if they sign a buyer agency agreement. If this is a seller that's moving locally and I can help them buy their next home as well, then I'll give them an even greater discount on the listing side. And I walk out the door with a signed listing agreement and a signed buyer agency agreement at the same time. So I could add back here, if I go back to this screen, I could add on a number 4. And I could say, I don't know, net reduction in commission of 0.5% if seller uses me as their buyer's agent for their next home. So any one of these programs we can do, and instead of 6%, I'll do it for 5.5%, and we could sign a buyer agency agreement there on the spot as well. Okay. Now let me go through as we wrap up here. I'm going to go back to the YouTube comment that spawned this discussion. And let's go through a couple of things here. I suspect the buyer will be responsible for their own errors or omissions in case of things failing, right? If things fall apart, then yeah, we're bound by the terms of that crappy contract. But that doesn't just negatively affect the buyer, it also negatively affects our seller. In all of the cases that we looked at, the seller winds up in a lawsuit with a homemade contract. So we really want to push back against that. And we push back, we don't have the authority to say, I'm sorry, we cannot accept this, unless of course our sellers give us that authority. But by law, we're required to present the offer to the seller, educate the seller. This is why we don't want to use these things. And we have options. I can go back to them and I can direct them to the proper state form, or we've got this option for limited agency. And I can get involved and I can help them through this process. And this is the fee that I charge for that. Okay. Again, he just says some of the stuff that he's suspecting this would happen. The court will go by the language of the contract, whatever you use. Okay. If it's homemade, there's not going to be an easy resolution. That court case could drag out for a long time because you could draw all sorts of conclusions from that. If it's a form like what we looked at, then again, I found 7 things just on my first scan through that could all lead to additional lawsuits from it. And by the way, if we went ahead with that form that we found online, and this did go to court, I've been called into court before as a professional witness. And one of the questions asked is this, I can't remember exactly how they phrased it, but basically, is this common for a real estate agent to use a form like this? Is this common practice? And if we say no, common practice would have been used to use this form. The follow-up question is, why didn't you do that then? And get and avoid your client being sued. Why didn't you encourage them to use the proper forms? Why did you allow this homemade form to go through? Okay. So be aware of that. The bar that we're held to often in court is, what is the common practice amongst other realtors? And if we're not operating at the base level, then we've got extra liability for that. And then some of his predictions here, a simpler contract. I don't think the contracts are getting simpler. I think they're going to get more complicated because there's going to be more lawsuits that potentially come from this. And so not everyone will use the Realtor Association forms. We're not even talking about Realtor Association. We're talking about a state-approved form, right? And if they're not using that form, we absolutely should be pushing back and make sure that they are. Otherwise, we have created huge liabilities for not just ourselves, but for our sellers, right? Sellers paying for less to get a property sold, no buyer agent commission, right? And he's talking about, hey, if there's no buyer's agent, they're not going to be thinking about asking for repairs and concessions for, termite damage. All of that stuff wouldn't be included in the contract. I think that might be a valid point with an unrepresented buyer. But again, if they show up with a home with termites and they didn't know that they could do these things, they didn't know that they could have those repairs, they're still going to sue the seller. Will that lawsuit go anywhere? No, but it may not. Well, I can't say no, it may or it may not. It all depends on how they wrote the language in the contract. But anybody that's played in court knows that simply going to court means you lost already, right? We've had court cases where you're spending $40,000 on attorney's fees and you're in the right. You won, but you're out 40 grand in attorney's fees and it drug you out for 2 or 3 years. And just the emotional toil of that on somebody, even though they're right, and sometimes especially when they're right, the fact that they have to spend so much money and 2 or 3 years fighting this they're not going to be happy with their agent that got them into that scenario. Okay. So do I believe that sellers are paying less to get a property sold? I don't think so. I think they're putting themselves at risk for paying more. More competitive agent pricing models. Not every realtor is going to charge the same. I do want to talk about this really quickly. Some will charge a commission, some a flat fee, others an hourly rate. Folks, you understand if you get involved at all, you're involved all the way. So if you're saying, hey, I'll do this for $100 an hour. That seems like a good rate. My first job was $15 an hour, or well, my first job was probably $5 an hour. So if I'm doing $100 an hour, that sounds phenomenal. So I get involved and I help them fill out the contract. It takes us 1 hour to fill out the contract and that's it. No, that doesn't work that way. The law doesn't work that way. I'm responsible for them for the rest of the transaction. And in Utah, there's a minimum level of service required by law that I have to perform. So if I get involved at all, I'm involved for the duration. So keep that in mind when you're determining your competitive agent pricing models, right? I wouldn't ever encourage somebody to do an hourly rate. There are a lot of agents that do a flat fee. That's fine. You can do a flat fee, but just understand you have to provide the full service. And again, that's Utah law. Buyers may have to pay their own agents. Could be, or they're negotiating it in the contract. Okay. More as-is sells, again, the result of simpler contract language. I don't think so. I don't think the language is going to get more simple. Every sell right now in Utah is as is. That's the way the contract language is written. So I'm not quite sure the point there. And then some transactions will fail because unrepresented buyers don't know what they're doing. I think that's indisputed based on my 20 years experience. A lot more unrepresented buyers fail than represented buyers. Now he says down here, someone who does enough research or has experience buying a home before could easily succeed representing themselves. I don't agree. Okay, my dad, who has bought and sold homes his whole life, he's now approaching 80 years of age. He would not do well on his own. It would not be easy for him. We're doing multiple transactions, in some cases a month. In most every case of a realtor, they're doing multiple transactions a year. Compare that to the average person that does one transaction every 5 to 7 years, right? That's not going to be easy for them. You don't remember the details and in every 5 to 7 years, it's almost guaranteed that the laws and forms have changed. And so what you were used to, even if you were meticulous in your detail, there's a very, very small percentage of people that have this engineering mindset or a lawyer mindset to go in and read and dissect this information and be able to truly consume it and understand what they're doing. So I don't believe that they could easily succeed representing themselves. And then he uses an example. If one is an all cash unrepresented buyer and they decided this is the property they want, things could go very smoothly. Why? Because an all cash buyer doesn't do inspections, right? They still need help with that kind of thing. Yes, that is the best example for a smooth transaction is all cash. You avoid all the lender scenarios. You avoid a lot of the appraisal issues that come up. Doesn't mean they know how to fill out a contract. And it doesn't mean they know how to navigate through their due diligence periods. And it doesn't mean, even if it is all cash, if they don't navigate their due diligence successfully, it doesn't mean that they're not going to come back and try to sue the seller. Say, hey, or sue you. Say, hey, this was all cash. I thought you would be helping me out with these inspections. I didn't know that I had to do this on my own, right? So even in the most easy scenario we could think of, there's going to be increased liability for a seller and for the agent. So this is the end of our discussion today. I'm going to go ahead and stop the recording.